Once in a while, a brave soul is going to call me and ask, how will USCIS know whether I change my worksite or my job duties if I don't tell them? And doesn't matter if I file an H1B amendment. Okay, so here's my answer. Remember, the burden of maintaining H1B status is on you. That means you have the responsibility to ensure timely filings of your cases. Yes, even if the employer is filing on your behalf, you have to ensure that your case is filed appropriately and on time because you have to maintain status in the country. So we're going to go over 4 common scenarios of how USCIS comes to know whether you maintained your status. The last scenario is absolutely critical for you to pay attention to, as it can have dire consequences for your green card. I strongly encourage you to check with your attorney and employer for case-specific filing strategies. If you don't already have an attorney and you need legal counsel for filing your case, please visit our website at www.immlegal.com and give us a call. We're looking forward to hearing from you. Hi everyone, my name is Sachin Raval. I'm a partner at Ramchand and Raval, where we practice immigration law. First things first, if you have any question about when to file an H1B amendment, please watch our other video on this topic. The link is in the description below. All right, so let's have a quick talk about how USCIS finds out whether or not you should have filed an H1B amendment. There are 4 typical scenarios when USCIS will come to know that your H1B terms and conditions have materially changed and whether or not an H1B amendment was necessary in order for you to maintain status. So scenario 1. USCIS often conducts site visits. Now, during the site visit, the H1B employee, HR manager, supervisor may be pulled aside and questioned about the terms and conditions of the employment. So the questioning officer is going to take down notes and ultimately compare the answers to the facts given in the H1B petition. If there's an inconsistency, USCIS may issue a notice of intent to revoke or request additional evidence for clarity. If it is found that there was in fact a material change and an H1B amendment was not timely filed, the H1B employee status, unfortunately, could be revoked. Scenario 2, USCIS visits a third-party client site and the beneficiary isn't available. If USCIS visits a third-party client site as the worksite and the beneficiary isn't available, that's going to become problematic. Remember, USCIS would have the address of the client site because that should be the address in the labor conditions application and the I-129. Again, in this scenario, USCIS will contact the employer and request additional information. If they don't get the answers they require on a timely basis, they'll likely issue a notice of intent to revoke. All of this stress could have been avoided with a simple filing of an H1B amendment. So the burden is going to be on the employer to establish that there were no material changes. But it's hard to do that when your client changes, if there's a new role, new roles and responsibilities, etc. Scenario 2. USCIS inspects documents at the time of adjudicating an H1B extension. Remember, the H1B is granted for a maximum of 3 years at a time. At the time of filing an H1B extension, the employers and their attorneys typically enclose multiple prior pay stubs. Sometimes 3, sometimes 6, but the pay stubs help establish that the H1B employee was paid according to the terms and conditions of the H1B filed. Pay stubs typically have the employee's full name and their home address. Employers have to do this to ensure they pay the proper state taxes, workers' comp, and among other things. If the employee's home address on the pay stub is not within a reasonable commuting distance to the work site listed on the existing petition filed with USCIS, USCIS will likely issue an RFE requesting why, an explanation why. If it's determined that you did not maintain your H1B status, your extension will be denied. Scenario number 3, upon re-entry into the United States. Let's say you're on H1B, you want to go to your home country and visit your friends and family, or perhaps you're going sightseeing, okay? Upon re-entry, CBP may ask you about your H1B, may ask you about the terms and conditions, your work site, your job duties. If at that point, it is determined that an H1B amendment should have been filed because the terms and conditions of your employment have changed from what was originally filed, you could be denied re-entry into the country, and even worse, it could be fined that you were violating your H1B status, which can create many headaches for you. As such, if you're going to go traveling, I recommend ensuring that the proper H1B amendments have been filed. And in most scenarios, I recommend upgrading an existing H1B amendment to premium processing to get a verdict on it. Why? Because if you're going for stamping, the officer who is interviewing you may issue you a 221G pending the outcome of that H1B amendment. We'll have a separate topic on this, a separate video on this, because I think it's something that many individuals are looking for clarity on. Scenario 4, our final scenario. At the time of filing your green card, your adjustment of status, USCIS will want to ensure that the H1B employee has maintained status throughout their stay in the United States. USCIS will compare your home addresses and your employer's addresses. If there is any gap or inconsistency between the worksite and the home address, for example, the addresses are not within, again, a reasonable commuting distance of one another, USCIS will request proof that amendments were filed in a timely basis. This is very important. A client of mine came to me with an RFE he received at the green card stage. USCIS's Phoenix office could not find the H1B amendment receipt and basically said the applicant may have violated status. So if the violation of status were true, his adjustment of status case would have failed, or at the very least become a very complicated and costly matter. Ultimately, we were able to prove that an amendment was in fact filed. The complication arose because the employer withdrew the amendment case as his project came to an end, but he withdrew it. So we're going to have a separate video on this topic, but in a nutshell, we strongly recommend that if the H1B employee began working according to the terms and conditions of the H1B amendment that has been filed, do not withdraw that H1B amendment. So to recap, not filing an H1B amendment in a timely manner can cause complications all the way up to your green card comes in hand. In my opinion, there are more upsides to timely and proper H1B amendment filings than there are downsides. Once again, the peace of mind that comes with filing an amendment is invaluable. And that is why I recommend filing an H1B amendment before joining, for example, a new worksite or having a higher salary or having new job duties. Remember, you can begin working based on the amendments filing alone. You don't have to wait for the approval. And that's it. Those are the common ways USCIS comes to know whether an amendment was necessary. I strongly encourage you to check with your attorney and your employer for case-specific filing strategies. Once again, if you don't already have an attorney and you need legal representation for filing your case, please visit our website at www.immlegal.com and get in touch. We're excited to hear from you. I hope you found this video helpful. If you have any comments, we'd love to hear from you. Don't forget to like and subscribe. More videos to come. Have a wonderful day.